Over the last few months, I've been working on this bill related to sexual harassment and harassment in the workplace. Because of the current crisis, it was put on hold till today, but we wanted to get it introduced. So just briefly, I do think it's appropriate during Women's History Month this month and during the 100th anniversary of women demanding the right to vote that this be introduced. But also I want to be clear that this is long past due, that we addressed what is really a deficient standard related to the definitions of harassment and sexual harassment in our laws. Over the last several years, we've seen the Me Too movement bring to light the pervasiveness of workplace sexual harassment. In 2018, there was a NPR reported on a survey that 81% of women and 43% of men had experienced sexual harassment. Current case law, however, has created the unreasonably high standard of severe or pervasive to prove harassment cases. And then in the absence of a codified definition, which is when you get case law for harassment or sexual harassment, current practice limits the ability for anyone to seek a remedy when they've been harassed. And if you think about the terms, severe or pervasive, what we're going through right now, should we wait till something severe happens before we step in and give relief? I don't think so. Here in Montgomery County, and I've heard from them, and in the coming months we'll hear from them, we have residents who have gone to court in circumstances where they were harassed but were unable to get help because of this inadequate standard. Over the last few years, our courts, government, and culture have begun to re-examine and address inappropriate behaviors in the workplace. What was once viewed as innocent jokes or fun has by most women always been viewed as disturbing and inappropriate. Sexual harassment in the workplace isn't just uncomfortable, it's frightening, and it leads to more problems. So thanks to this Me Too movement, we have been naming this problem and starting to make changes. We've started to see an uptick in reporting of sexual harassment, but the truth is that the incidents have always existed. So it's time we do something about it. This bill will set clear definitions in statute for harassment and sexual harassment, and it will explicitly remove the severe or pervasive standard that allows, and it will switch to say that a reasonable victim of discrimination would consider the contact to be more than a petty slight, trivial inconvenience, or minor annoyance. And this is similar to action that was taken in New York State, who passed this statewide in changing this standard. Simply put, we are going to make the workplace more professional for all, no matter who you are. And so I had other remarks, but I'm going to pause there. I do want to thank the community advocates who we've worked with on this and have worked collaborative with me to share not only their feedback, but their stories and their recommendations. And we'll hear from them in the coming months. I also want to thank Councilmembers Navarro and Glass for co-sponsoring, and I hope my other colleagues will support this important legislation to improve and modernize our workplace harassment policies. Thank you.